the city attorney's office is present on behalf of Tucson City Court. At this time, the first issue that comes before the court is there was a motion to quash the civil subpoena for appearance and testimony of Alan Merritt. The defendant filed a response. There was substantial disagreement about what testimony Mr. Merritt could provide. So at this time, Mr. Brown, I'll give you an opportunity to provide me your proffer as to what testimony Mr. Merritt would be able to provide. I did excuse him from being present today, but said that I would reserve ruling on that to give you an opportunity to be heard, as well as the city attorney to respond. So go ahead, Mr. Brown, tell me what testimony you believe that Mr. Merritt would be able to provide that would be relevant as to the issue as to whether or not you were disruptive in court. Go ahead, sir.
Yes, sir. In the response from the city, that was outright lies. What it said was Mr. Merritt wasn't there. He witnessed none of it. He was there the whole time. When you watched that video that we saw last time, he was the one calling roll call. So that was Alan Merritt. He saw the whole thing. He knows about the disturbance that Christopher Hill caused, and he knows about the whole thing from start to finish. He was there. It doesn't say that Alan Merritt said that in the report. It said Rossetti, or there's some lady that wrote a thing, I guess, lying for him, or he might not even know about this. But Rossetti said that he wasn't there, and that's outright lie. And you saw the video, and Alan Merritt is the guy that was calling roll call in that room, I think 102 they call that. And he was absolutely there. He saw the whole thing, and he knows a lot of stuff about why Christopher Hill did what he did.
All right, and I'll hear from the city attorney with regard to the motion to quash the civil subpoena for Mr. Merritt.
Your Honor, I'm discussing this without having actually seen the motion. But,
okay, no, that's fine.
But nevertheless, I will concede that I've seen the videotape, and I recognize Mr. Merritt, and I recognize that he was present at the hearing.
Okay, and MJ Rossetti did file a motion to quash the civil subpoena. And I did excuse him from being present today, so there would be no sanction for him not being present today. I didn't want you to be concerned with that.
Yeah. Your Honor, I will concede Mr. Brown's point that Mr. Merritt was visible in the video.
All right, in that case then, what I will do is I will require that Mr. Merritt does appear for another hearing unless at today's hearing, based on the defendant's case, we're able to reach a ruling today. And we've now moved past the plaintiff's case. I did find that the plaintiff made a prima facie case. Again, that does not mean that I've found by a preponderance of the evidence, Mr. Brown, that you did in fact commit the two acts, just that there is testimony in the record to support that. So, Mr. Brown, do you have any witnesses present today? Other than Mr. Merritt, and I understand I'm not going to require that you produce him today because I reserve ruling.
All the witnesses that I subpoenaed, all the cops are not here. There is one here. Larry is here from court security. None of the cops are here. I subpoenaed Sherman. I subpoenaed Wilson. And I subpoenaed, there's several of them I subpoenaed.
Okay, well, let's hear from the witnesses that you do have today. Okay, do you have any witnesses? Have witnesses that are present today?
The main ones I wanted to start with is the police officers, and none of them are here. The ones I wanted to start with.
Well, let's go, in the interest of efficiency, let's go with the ones that you do have here, okay? And I'm not sanctioning you for not having them here. I realize you subpoenaed them. We'll deal with that. We will deal with that. I'm not saying I'm going to ignore that issue, but let's deal with the witnesses that you do have so they can be excused, okay?
I guess I could start with Vernon Peltz. He's out in the hallway.
Okay, and he was a witness to your. Okay,
yes.
Go ahead.
And a few of the witnesses I called up last night when I got this letter saying we wasn't going to continue. I told a couple of them that they don't have to be here. Only a few of them did show up that I couldn't get a hold of. So I was under the impression that we was going to have a hearing just on this motion as soon as I got that letter. And
okay,
I didn't.
Are you not ready to call your witnesses then?
I have a couple of them that I told actually not to come here. They're primary, but we can start as long as you can allow me time to get them also. Because this might go into another day if we have to get if we have to bring in Alan Merritt.
Okay, if we're going to bring in Mr. Merritt, let's take a look at schedules, and I'll allow the city attorney to consult to see when Mr. Merritt is available. Let's take a look when we have enough time to. And for the city attorney, if you've had an opportunity to see when Mr. Merritt is available, how does September 17th look? If you could just check and see what his schedule looks like. I'm trying to do the best we can to accommodate everyone.
We'll be in touch with Mr. Merritt,
Okay.
see whether he's available.
What's the date again? I'm sorry,
September
September 17th at 3 p.m. would be in the afternoon.
Yeah.
Sure, go ahead, take a minute, see if he has an opportunity to let you know what his schedule is at that point in time. So, Mr. Brown, would you like to check with your witnesses that are here in the hallway to see if that date and time would work for you?
Oh, is this to move everyone back, or are we
To
gonna
move
start?
everyone back to September 17th at 3
Okay,
p.m.
yes.
You want to take a minute to check with your witnesses? Okay.
Mr. Merritt's available.
Okay, very good.
Yes.
That works? Okay, so we'll bring everyone back here September 17th at 3 p.m. The current order remains in effect as it was until that time. So we'll reset this for September 17th. I will order that Mr. Merritt appear to testify. And Mr. Brown, I do remind you that because in your testimony, you admitted that you did film Mr. Hale, that issue, as well as the court's order regarding filming, that has been decided. That's something that's been decided by a higher court than me. So, and I'm not saying that you can't take this up. You have the right to appeal that, and you have the right to appeal it further than the Superior Court if you choose.
But can I mention one thing?
Yes, go ahead.
When I was on the stand, and my witnesses are gonna testify that the group had permission. I said that I probably did, and I might have recorded Mr. Hill, but I didn't do it without his consent, his express consent. So we gotta address that, because that's the whole January 2nd incident.
Okay,
And that's, and I have 3 witnesses for that,
Okay.
including myself.
And Mr. Brown, I recognize that you disagree with the court's ruling on that, and I appreciate that. However, I do find that based on the court's recollection of the testimony, that you did admit to filming Mr. Hale without his personal consent.
Yes.
So that is the finding of the court. So that issue has been decided for the purpose of this
Yes.
hearing. And I'm not trying to preclude you from appealing that.
Yes.
If you want to appeal that, you can appeal it to the Superior Court. You can appeal it higher than that if you choose. Okay?
But what I was saying, I didn't get it put on my case about the consent yet.
Your Honor,
So,
I would argue that Mr. Hale's consent is irrelevant, given Mr. Brown's legal position that Mr. Hale is a member of the court and therefore not an individual subject to the jurisdiction of the rule.
And I already found that you filmed Mr. Hale without his consent. So that issue has been decided. So the only issue that remains is to whether or not you were disruptive in court on the separate date. That's what you'll be permitted to contact or to call witnesses to, is to whether or not you were disruptive in court. Because when you testified, you did not admit that you were disruptive in court. That's the issue that remains. All right, sir?
yes, yes.
So, and again, I'm not trying to prevent you from taking this up higher as to whether the court's procedural rule is correct or not. You can take that as far as you're able to. But there is a court that's higher than me that's already decided that that rule was proper. All right, so when we come back, the only witnesses that will be permitted to testify go as to whether or not you were disruptive in court
On the 24th
on
of,
the 24th.
okay, correct.
So that goes, and that is what Mr. Merritt would be testifying to. That's the only thing that he would be testifying to, is whether or not you were disruptive in court. All right,
Okay,
sir?
and one other issue, sir.
Yes.
I'd like to, actually 2 other issues. One is about Judge Rojas, and the other one is about the plaintiff give you 2 papers at the end that I didn't get to see. I believe one was Judge Gordon's decision, and I just want to know what 2 papers he gave you. And did the other thing he give you was Judge Rojas's rules of June 5th, 2019. Did you give him that?
Your Honor, I provided the court with copies of the new superior or new city court rules that have been promulgated by Judge Rojas, as well as a copy of the December 26th, 2018 decision in Mr. Brown's prior case.
Yes, and I believe these were,
I think they were admitted as 3 and 4.
yes. And
Okay.
what we'll do, Mr. Brown, just to make sure there's no confusion, we'll make you copies of that, all right?
Oh, great, thank you. And that's why the Judge Rojas was so important, because in the opening statement of the plaintiff here, he said 4 times that I have to comply with Judge Rojas's rule of 2005. This is prior restraint. I wasn't even in there since that rule came out back in that time. I have since. But he's trying to say that I have to comply with Judge Rojas's rule of 2005, and that is against Rule 122.1. It's the exact opposite. It says that you can't record, they say, and it says you have to get written permission from the person you're recording on theirs, and you've got to get permission from your masters. You've got to submit that to the court administrator, then the court administrator gives you permission to do it. And I won on that ruling. On Judge Gording's ruling, if you read on that, it says they changed my ruling from getting permission from the presiding judge after they came up with his decision, and they switched it from getting consent only from the person. So I won on that. And both these 2 courts, city court and this court, got rules saying now, because of me, that we have to get